Yeah, the floor
Thanks,
is
Kim, and
yours.
thanks, Alexis. This has been a great conference, and I've really enjoyed having an opportunity to visit with everybody during the evening session networking, and have been kind of previewing what I would be talking about. I think it's important for you to know a little bit about my background and why I am so passionate about CRPS. About 24, 25 years ago, my former law partner, who has since retired, got me involved in trying to help people who had CRPS from a legal standpoint, from workers' comp back in the day. And we realized that there were opportunities to bring lawsuits against not the employers, but other entities that cause people to get injured and have CRPS as the result. And so we started working with clients and just getting to know them, getting to understand the horrific condition that CRPS is, and working with them to put together their case and meeting their family and support team, and realizing there was a real need out there for the lawyer. If you had a legal case, for a lawyer to understand and empathize with the people, because it's such a difficult road. And I'm a very holistic approach type lawyer. In the last 5 or 6 years, I've probably done, 25, 30 or more cases all over the country. And what I try to do is I try to bring, just in addition to bringing a legal background, bringing a counseling background, because I've had so much experience with working with people with CRPS. And so I get a lot of questions about, do I have a case? Unfortunately, most people, including the people I've already talked to, don't have legal cases. It's a rare time when you find that you do have a legal case. But if you do, then I want to kind of give you some guidance about whether I'm your lawyer, a potential lawyer, or whether you're thinking about hiring a lawyer and you have some questions. So first of all, the big question, threshold question, is, do I have a legal case? Trauma, as you know, is what causes CRPS, and trauma can be caused by a car accident. You can slip and fall and break your wrist, or have a scapholunate fracture, or get a trigger finger, and as a result of that, you can develop CRPS without any type of other intervention. You can get a fracture or a sprain or a laceration in any kind of injury. You can develop CRPS. On the workplace, we see a lot of people who get injured by fellow employees' negligence, but in every state except for Texas, and I happen to be a Texas lawyer, although I practice all over the country, you're not able to sue your employer if they have workers' comp. You have to go through the system. And I've been talking to some people, and it just reinforces my belief that it is very difficult to find much justice or relief through the workers' comp system, because it is designed not in favor of the injured worker employee. It's designed in favor of the employer and the insurance carriers. And so a lot of times my clients, even, they initially get injured on the job, but let's hypothetical speaking, it's caused by the negligence of a third party. Like somebody is at a warehouse and the delivery driver is not paying attention and runs them over, and they get a fracture and develop CRPS as a result. Well, not only do they have a workers' comp claim because they got injured on the job, but they also have a claim against the third party delivery service driver and his employer company for negligence, which is outside of the workers' comp system. So we have to work with workers' comp carriers a lot. And I've just watched them abuse people who are potentially in the early stages of developing CRPS, because, they're incentivized to get people back to work or get them off the insurance payroll. And so they're not going to get the best treatment as a result. In Texas, however, if a workers' comp if an employer decides to opt out of workers' comp, which they're allowed to do, then you can sue them for negligence, just for workplace negligence, failing to provide a safe place to work. Texas is unique in that. and it gives an opportunity for myself and other lawyers in Texas to represent people who have CRPS and go against the employer for failing to provide a safe place to work. An example would be another, warehouse where a co-employee is driving a forklift and accidentally runs over somebody's foot, and as a result of that, they develop CRPS. Well, a co-employee's negligence is attributable to the employer, and they failed to provide a safe place to work, so you can sue them. So that is a kind of a unique opportunity in Texas, unlike other states where we try to help people with CRPS. And so all of those are directly related to the trauma, i.e. car accident, slip and fall, trip and fall, workplace injury. Indirectly related is if you get in an accident, you get rear-ended by a car, and as a result of that, you get a herniated disc or you get a fracture, then as a result of those injuries, you have to have surgery. And as a result of the surgery, as most people know, it's foreseeable that you can develop complex regional pain syndrome or reflex sympathetic dystrophy or nerve damage that results in that. In fact, it's in the informed consent that you sign before you get the surgery, and most operative notes, you're going to find it as well. They're in there because it's foreseeable that any surgical procedure could result in CRPS. So you don't go after the doctor unless they did something wrong, and I'll talk about that in a second. What you're going after is the entity that caused the injury that resulted in the necessity for surgery and the resulting CRPS. So it's indirectly related, although it's still causally related. The next potential claim, and I see this probably more than any other potential claim, and typical situation is somebody gets diagnosed with CRPS and they go home and they Google, CRPS diagnosis, and a lot of times they're upset at their doctor because they don't understand, that this stuff can happen, because they don't typically look at the informed consent, because typically nobody really does. And so they don't understand that this is a complication that can happen. And so they're not okay with it being a foreseeable complication. And so they want to sue their doctor, or they want to sue the nurse, or they want to sue, a medical assistant that maybe did a needle stick and resulted in CRPS. But unfortunately, there's very, very few times that you can sue a doctor. There's really only two possible ways. One is that it's an unnecessary procedure. Then you don't have to prove the doctor did anything wrong, because if the doctor shouldn't have been operating you in the first place, and you prove that by showing the clinical diagnosis was wrong, the objective testing, the diagnostic testing that they did or didn't do would have shown that they didn't need to do the surgery. I have a number of those cases, and they're rare, but they're definitely out there. And you go, after the surgeon, because but for the surgery, even though he didn't do anything wrong in the surgery, the CRPS resulted. An example would be somebody who has a foot surgery that maybe they didn't need to have the type of surgery or a surgery at all. Maybe there were other conservative measures that diagnostic imaging didn't show that there was, the laxity in the foot or something like that, that was necessary to result in the surgery. So those are the easiest medical malpractice cases from my perspective. The more difficult ones are if you have to prove that the doctor did something wrong. The most obvious is when they cut a nerve. Now, I'm here to tell you, and most people don't really like to hear this, but just because a doctor cuts a nerve during a surgical procedure does not in and of itself mean that they committed medical negligence, that they did anything below the standard of care. There is certain risk, and that's why it's in the informed consent, about doing medical procedures. And unless a doctor did something wrong, the clearest example I have is I had a client who had a cubital tunnel release done endoscopically, which means it was visualized by with a cannula. And even though the doctor could see and visualize the ulnar nerve, the doctor still cut the nerve. Now, that was a clear-cut case of medical malpractice, and we were able to get that case resolved, favorably for our client. But when you do foot and hand surgery, which we see a lot of CRPS result as a development because of that, it's not as clear-cut as you would think. When you're messing with nerves in the foot and messing with nerves in the hand and the wrist, there are so many, bundled nerves. So it's always going to be a risk. Those are more difficult cases. I've done more recent cases with needle sticks. And, I don't know if there's a crisis out there with phlebotomists or medical assistants or nurses, but I see more and more of these where they're not attempting to do, an IV in a place where it's appropriate, even though there's clear guidelines saying, you need to look at certain areas on the arm before you go to an area that may be more at risk, that may put the ulnar nerve or the median nerve at risk. If you can prove that they failed to do that, and as a result of sticking the needle in, basically insulting the nerve, resulting in a neuroma or something like that, if you can prove that, then you potentially have a case. Now, the problem with those cases, though, is that the medical records almost never support that the person said, oh my God, they stuck me right in the nerve and I cried out in pain and I asked, why did you do that? I mean, it's never in the medical records. It's usually uncomplicated procedure. So it's rare, but we do have, every now and then you'll see that there was a neuroma or there's some visual evidence immediately, some swelling or something to indicate, that the whoever was sticking the needle did it in a wrong area. Or the other way is maybe it wasn't in the wrong area, but they did it incorrectly and they hit a nerve, and the person cries out and they don't immediately take it out. They continue to dig, which it sounds awful, but we see that a lot. And as a result, you get nerve damage. And, anytime you get nerve damage, you potentially could have CRPS. So let's say you have a case. Now what? And this is where, you need an expert lawyer who understands the dynamics of CRPS, because you have to prove causation. Without causation, you don't have a case. And you were like, well, I have CRPS and I was in an accident. It seems like it would be that pretty easy. It's not always that easy. There's always other potential causes. We'll talk about that in a minute as far as, the defenses that we see. But you need an expert who's going to testify the trauma causes CRPS. My favorite expert is a pain doctor, your pain doctor, who is a treating physician and is willing to testify that the car accident, which resulted in, a fracture, which developed into CRPS, was the cause of your development of CRPS. Or you had a car accident, and as a result of the car accident, you got a herniated disc, and as a result of the herniated disc, they had surgery, and as a result of surgery, you developed CRPS. The treater is not going to be critical of the doctor because the doctor didn't do anything wrong, but the treater will say that the driver of the car that caused the accident, that's the cause of your CRPS. That's my favorite expert. You can also get, in a surgery case, you can get the orthopedist or the neurosurgeon that operated on you, because they're going to be like, it wasn't me. I didn't cause it, as in like I didn't do anything wrong, but they're definitely going to be able to say, well, yeah, but for the accident which resulted in the scapholunate fracture, I wouldn't have had to do surgery. And if I hadn't had to do surgery, then even though I did everything by the book and did it exactly as I should have and didn't do anything wrong, this person developed CRPS. That's another powerful way to get testimony on causation. If you don't have those, you can always consult with a neurologist or a physiatrist, physical medicine and rehabilitation doctor. Or if you don't have those, in some cases, I've got a case that recently resolved where my client goes to Cleveland Clinic. I mean, you would think Cleveland Clinic, the gold standard, like Mayo Clinic of treatment, and the head of the pain clinic there, who's deposed, you would hope that he would be a patient advocate and he would help his patient put the ball through the hoop from a legal standpoint. I mean, it was pretty clear. She slipped and fell. She had trigger finger and wrist damage. She had surgery. As a result of the surgery, she developed CRPS. As a result of that, she goes to the Cleveland Clinic and she gets the stellate ganglion blocks and ultimately gets a spinal cord stimulator. It's pretty obvious the surgery is what caused it, because she went for a couple years without surgery after she tried everything conservative, but eventually had to have surgery on her hand. But the doctor wasn't willing to give us the testimony. So we had to go out and hire an expert who was able to review all the records, did an independent medical examination of my client, and was able to say that, yes, it was the surgery which caused the CRPS, and as a result of the slip and fall, that's why the surgery was necessary. And so therefore the slip and fall is what caused the CRPS. We had to have that from a legal standpoint to jump through the necessary hoop. But I was very disappointed that the treating pain doctor wasn't able to give me that, because juries tend to like, from a credibility standpoint, juries like people who don't have a dog in the fight. They're treating physicians versus, my hired experts or a defense hired expert. Treaters just have a lot more credibility. So, okay, you get your causation done, right? Then what's next? Then we build your damages case. And these are the experts that we have to use, that my team, uses. I've got people all over the country that I use for these, depending on the location that you may be in. I don't know if I've said it before, but I practice all over the country. I work with lawyers in all different states on putting together these cases. You have to have a life care planner who will take a look at whatever treatment you've been receiving and come up with a plan as far as what your future is going to look like. In other words, let's say you either already or will have a spinal cord stimulator. Well, battery replacement for that, depending on the guidelines that they're consulting with, are 5 to 10 years, 8 to 9 years, depends on Medicare versus other health insurance, or what type, if it's Boston Scientific or whatever. But they come up with a plan. And so let's say you're in your 40s. Well, you're going to have another probably 3 or 4 of your lifetime battery replacements. And the studies say after 20 years, you might need a total new stimulator. Well, that's expensive, right? But we put that together in a life care plan along with other modalities of treatment. Let's say you don't want to go the route of blocks and a spinal cord stimulator. Let's say it's Dr. Chopra, who doesn't like those. He wants you to go, the ketamine route. So let's say you go ketamine. Well, that is also extremely expensive. And we have to price that out and put that into a life care plan as well. Vocational rehabilitation expert, as everybody knows, it's very disabling to have CRPS. And because of the pain, because of the medication you're on, because of the brain fog and the depression and just the cycle that CRPS causes, it's sometimes it's impossible for people to go back to do what they were doing or to go have any kind of job. And we have vocational rehabilitation experts who are going to be able to take a look at you and your earnings, your past earnings, what field you're in, what your promotion possibilities were if you hadn't been injured, things like that. And they come up with different scenarios. Like if you're never able to go back to work, that's scenario A. If you can go back to work but not doing the same things and making less money, that's scenario B. And if you're, able to go back to work, but you can't do it for like 5 or 6 years, something like that, be scenario C. And you get an economist who has to crunch all the numbers, crunch the numbers on the life care plan, crunch the numbers on the vocational rehabilitation expert, plan to present value, and you come up with the non-economic damage model. Now, one thing that that I put in actually this afternoon into my PowerPoint because of our great presentation yesterday, I think it was Nancy Powers, on service dog, reminded me that I had a client who, fortunately, she had the resources. She got a service dog, a white lab, great dog, had it trained, everything necessary. And it not only was it her service dog, but it was her therapy dog. It was her comfort dog. I mean, this dog was amazing. She would have a flare up, and he would just sense it, and he would go over and he would stand next to her. He'd put his paw on her. I mean, it was just amazing to watch the difference with this dog and my client. But it was really expensive. So the price of the dog, the training of the dog, the feeding the dog, the vet care for the dog, we put all of that into our economic damage model because clearly, but for her having CRPS, she wouldn't have had to have this really, really expensive dog who made such a big difference in her life. So that's something that we can also do as we try to put together these damage models. Non-economic damages. Unfortunately, there are states around the country where legislatures have decided that they're going to arbitrarily put out a value on your pain and suffering and mental anguish. Like in Colorado, it's like $600,000 and change. In Idaho, I think it was like 500,000 and change. And that is for not just medical malpractice. That's for you get in an accident. The legislature has deemed that to be the amount that you can ask for. A lot of states, including Texas, there is no limit. We put together a non-economic damage package, which is your pain and suffering, your mental anguish, your impairment, your disfigurement, right? Those, how do you ever put a dollar figure on that? So we have a psychologist or a psychiatrist. It could be your treating psychologist or psychiatrist, because most people who have CRPS, there's a psychological overlay to it, and it's just a cycle of depression. And so people go and they get, psychological help. I've had a pain therapist I used in a case in Colorado who was amazing, because my client who was going to her was talking about how the pain was just controlling her life, and they were trying to work through that. And in her deposition, she was able to really talk about the horrific impact that CRPS has had on my client's life, and disabling and depressing, and things they were trying to do to work through it. So we put all of that together to build our damage model. So from a legal timeline, right? Lawsuits filed, then you have written discovery, depositions can take a while. It's all working towards one of two things. One, you'd go to mediation, where everybody tries to get together and get a case resolved. The vast majority of my cases are resolved at mediation, because there's so much risk from the insurance carrier standpoint, because if a jury truly understood the nature of CRPS and truly understood the nature of how affected people are by it, and I pull out the McGill pain scale when I go to mediation, and I say, the most painful condition known to man, more painful than amputation of a digit and natural childbirth. And, it's insurance adjusters who are there, they just grimace. They're like, oh, that's just awful. Well, that's what you want, right? That is what you want. So there's risk from the insurance carriers. And if we work the case up properly, then we have prepared them to make an offer that hopefully our client will be able to accept and will get financial security for. But if that doesn't work, then, we're prepared to go to trial. And it is an emotional thing for people, but sometimes it's just necessary. And a lot of times they get to tell their story. So what are the issues that are coming up that I'm seeing? I've been litigating these cases for 20 to 25 years or so. The threshold question that you get is, does the defense lawyers, do they buy the diagnosis of CRPS? It's rare, but it happens. And when it happens, it's great because then you can just focus on the damage model. You can focus on the non-economics, trying to drive that as much as possible. Focus on the life care plan, the vocational rehabilitation if necessary, if applicable. And you don't have to worry as much about circling the wagons on causation. But more than likely, the defense is going to disagree that CRPS is what your client has, right? And so how do we do that? Well, we have to defend the diagnosis, basically, right? You get the treating doctor, you get any other, therapists, if they're there, as many doctors as you can get, and you try to put the defense on an island that they have hired a doctor to say that you don't have CRPS, but they're on an island because everybody else agrees. So you try to make them look like they're just buying an opinion, which is one way that we do it. But sometimes we do have to rule out the other causes. We have to get our clients' medical records. Sometimes they have pre-existing psychiatric conditions, and that there's nothing wrong with that. That's something that we have to deal with, because if somebody does have a pre-existing psychiatric condition, then potentially that could definitely, as a CRPS, that could result in even more psychological overlay due to no fault of the person who has it, but that they happen to have a history, and this guy who was negligently driving his car, he owns that. He has to buy that. And that's one way we do, is we try to rule out any other pre-existing or other causes of the CRPS. And the one thing, that we see a lot is independent medical examinations. I'm not in favor of them. Obviously, I don't want my client to have to be subjected to painful testing and, doctors that are very dubious and skeptical of their claims and are trying to poke holes and figure out a way to claim that they don't have CRPS. I'm against that, but most courts will allow, especially when you're, putting into issue your client's medical condition on such a condition, they will allow that to happen. And I try to control it. I try to limit the scope of the examination. I try to limit the time. I try to limit how much they can get into as far as the past medical. And if I can get an agreement, I get it videotaped, I get it audio taped. I have a third party observer. I've sat through some of these. It's not fun to see your client basically tortured, but it's a deterrent if you have a third party sitting in there for what they can do. And then if they lie about it in their deposition, you can cross-examine them on it that they're not telling the truth from what we got it on videotape. But it is something that we have to deal with in most cases. And I've yet to find an independent medical examination where the doctor's like, you know what, this one, yeah, she has CRPS. It's horrific, and you guys just need to pay. Now, that's not what they're paid for, and that's not why they continue in business. And so it's just a necessary evil that we have to deal with. How does such a seemingly minor event result in such a devastating condition? That is something not only defense lawyers say, but we hear that in focus groups all the time, because they're like, how did this ankle sprain, when this lady stepped in a hole, she had an ankle sprain, that should have healed in 3 or 4 weeks and she should be fine. But how did that develop into such a hideous condition where her leg is all swollen and discolored, and she claims her temperature is different, and she says, that the pain is such, it feels like somebody's putting my leg into a vat of molten metal, or it's on fire, like dragons are breathing on my leg. I mean, it's an ankle sprain. I mean, how did this result in this millions of dollars of medical you're asking for? And saying that you can't work. I mean, come on, we're just talking about an ankle sprain. I mean, that's the biggest hurdle sometimes we have to overcome. And so much depends on the credibility of your client, of the patient. If they're not credible, if they fudge on anything, boy, it really comes back to bite you. But if you're strong and you're credible and your lawyers have built you a good case, you can overcome that. But it is an issue. And I'm sure even if you don't have a legal case, I'm sure people at home are like, hey, you just fell down on the ground and sprained your wrist or whatever. I mean, and now you're telling me that your arm's on fire. I mean, you look fine. Okay, you got temperature change. That's kind of weird, but I mean, you look fine. Let's go do whatever we normally do. And people just don't understand. So it's not limited to lawsuits. It is a problem that as you guys know, you CRPS warriors know, you have to overcome the presumption that nothing's wrong. You have to be able to talk about and communicate so that people understand what you're really going through. Another angle of attack is your medical treatment is unreasonable and not appropriate. And, I can't even think of a case I've had where they're like, you're right. Spinal cord stimulator, that's a good call. We'll pay for whatever the future is on that. And you know what? We'll throw in a pain pump and some other stuff on top of that. No, they're not going to do that. They're going to say, well, the literature says that spinal cord stimulation after 3 years can be ineffective, and they come out in some people, and so we're not going to pay for we don't want to pay for any of the future because it's so uncertain that it really works. And even if they say it works, how are we going to believe them because it's subjective? So they're gonna fight that. Ketamine, oh my, when you have a client who decides to go the ketamine route, just lawyers, we have to deal with it, and we see it more and more. I think the literature out there, it's not as strong as it could be, but because of the nature of ketamine, we don't see the same kind of support that we see from the scientific community on other modalities. But ketamine, it's non-invasive and it works. So what you have to be able to do is communicate to the defense and a jury, a judge, adjuster, whoever, that this person is not taking ketamine because they seek a high. They're not doing it because it makes them feel good. They're doing it because it's the only freaking thing that gives them pain relief when nothing else works. That's hard to communicate, but it's something we have to do. Same thing, like, I get that the nerve block work, but geez, you had a series of 3 nerve blocks times 4. I mean, that's just unreasonable. No jury would ever agree that's reasonable. So we have to explain the science behind why, therapeutic and diagnostic nerve blocks are necessary. And sometimes, people decide they want to do those and come back and get the nerve blocks instead of having a spinal cord stimulator or other type of invasive modalities. Ketamine, and I told somebody I would talk about this the other night in the booth, but ketamine has been designated as an orphan drug by the FDA. And as a result of that, there's going to be a lot more scrutiny on it, but fingers crossed, maybe FDA is going to bite off on ketamine as an approved drug for the treatment of CRPS. And if so, then, health insurance is going to have to cover it. Because right now, as you guys know, hardly any health insurance plans will cover ketamine because it's deemed experimental. Another area that I'm seeing more involvement in now is the use of a blood product called Ivig. I had a client who was diagnosed with autoimmune disorder, with POTS, with common variable immune disease, CVID, and the immunologist was treating her said, if we can address the autoimmune disorder, which is potentially causing the small polyneurofiber issues, which are aggravating the CRPS, if we can address the underlying cause of that flare, then potentially we can control your CRPS. And so the way to do that is with Ivig. an extremely expensive product. If it works, then that's great. And I know Dr. Chopra, I don't know if he did it this time, but Dr. Chopra has been talking about IVIG as a way to address the autoimmune disorder, which underlying affects your CRPS. The abuse of narcotics and opioids, I'll address that a little bit more on my next slide. But of course, defense lawyers are like, your client's pill popping, pill seeking. They're addicted to opioids. They're just part of this opioid thing. Jury's not going to believe them. They're going to think they just are doctor shopping to get pills. We hear that all the time. Again, something we need to address. And then when I say other, so I've got some clients who have been, one of them went over to Italy and did the Neradronate drip experience and had a good result, and is hoping that, eventually the U.S. is going to adopt that as well. The Pamidronate, same client, did a trial of that, and it was not quite as effective, but it's another, route to go. So I think we're going to see more and more of that as time goes on, and as people, are experimenting with potential drugs that are going to, help with the pain relief. And I've got out of the box here, right? Because out of the box is thinking differently than just your standard spinal cord nerve stimulator or ketamine or blocks or anything like that. There is obviously most of you guys, because we've talked about it, they know about the Spiro Clinic in Fayetteville. Dr. Katinka up there does wonders. But from my perspective as a lawyer, I got to be honest with you. I've told clients that I don't recommend during our lawsuit that they go to the Spiro Clinic, because it's a little bit hard for me to defend that when I'm bringing or prosecuting a lawsuit. But I tell them when it's resolved, and hopefully we've gotten you enough financial security that you can do this, by all means, if that's what you would like to do, go, because it's hard to argue with her results. Finally, the defense that I just can't stand the most is probably, well, just go back to therapy. I mean, how many times have you gone to physical? Let me look at your physical therapy chart here. How many times have you've only gone to therapy 10 times, where, if you'd gone 25, you'd be fine now. I mean, that is such BS. But you hear that. Functional restoration, that's the number one thing for getting people back off their feet on CRPS. And if you just gone to therapy, then you would be fine. So we have to overcome that as well. So Jim and I talked before this presentation about, I said, what are some issues that people have that, maybe I haven't addressed in the past, or maybe I can put some thought into. And he talked about how there is a crisis now with the undertreatment of pain management because of the opioid crisis. My law firm has been involved in representing the Dallas County in the opioid case against the manufacturers and distributors for causing the carnage that they did in our hospital districts and in our county. And I'm proud of that. But I will tell you, though, that because of the opioid crisis, there is definitely a gun kicks as hard as it shoots. There's a reaction by the medical community, and many of y'all have experienced it, where the doctors are gun shy. They don't want to get investigated by the FDA. They don't want to go to jail because they're prescribing narcotics and opioids. And a lot of times they just throw their hands up and they say, I'm sorry, I can't help you. So it's patient abandonment. And it's and we're seeing it a lot. And I think there's some thought out there that pain management is a right. And if a doctor is not going to give you appropriate pain management that you require because of your condition, can you sue them? I haven't done that. But I know there are some lawyers out there that are thinking about, not from a CRPS standpoint, but just from a pain standpoint, doctors who refuse to provide palliative care or narcotics for chronic pain. Are they breaching their standard of care? I think that's an open question. What are the damages? I'm not exactly sure, but that potentially is something to be watching. And Jim, thank you so much for sending me this article, but he sent me an article on an advocacy group, which has recently formed for people with chronic pain to try to get their message across. And the founder of it is civil rights attorney Kate Nicholson, who's former U.S. Justice Department. And here's their mission statement. And I couldn't memorize it, but I think this is really, really helpful. And I think people who are feeling like they're being undertreated for pain management, this is a place for them potentially to go and use as an outlet. But their mission statement is an alliance of clinicians, scientists, civil rights advocates, and people with lived experience of pain or addiction. We view pain treatment as a health equity and rights issue and are fortunate to have the country's leading expert on pain, addiction, disability rights, and health policy among our ranks. So I would encourage you to look up the National Pain Advocacy Center, started in March of this year, as a possible way to express your frustration and channel your energy in trying to get change so that this issue of undertreatment of pain management, abandonment is taken up as a cause, and maybe we can get some good legislation to get that changed. So I told you I'm a holistic lawyer, and I do firmly believe in the power of positive thinking. And a lawsuit is not anything anybody would ever want to willingly go into. And there's a lot of dark times. And I just try to be really strong and positive with my clients. Amberly Lago, who I met 3 years ago at Charlotte Wellness Conference and saw the other night. She has really perfected the art of positive thinking. And I wrote down a couple things she said. The main thing that really stuck with me is you can choose to be a victor instead of a victim. And boy, that is really true, because you can let CRPS just totally define your life. You can let pain define your life. And in a lawsuit, if you do that, the defense lawyers are going to figure out, they're going to see that you're weak, and they have an opportunity to attack and to make it seem like you're seeking secondary gain, or you're malingering, or the horrible things that they do. You have to be strong, whether it's in a lawsuit or just in your community. And so just take care of yourself. And when I prepare clients for deposition, we spend a lot of time together talking about their life story, because people don't realize the loss that they have as a result of this condition and how it affects their loved ones, their family, their support group, until they really, really open up. So I encourage you to open up, whether it's with your lawyer or your counselor or loved one, because they need to understand. I don't understand fully until I just really peel the onion back and I fully understand what's going on with my client. And ultimately, what I tell them is, we're not going to let CRPS define who you are. We are not. And tomorrow, or whenever you give your deposition, that is the day that you take back your life. And I mean that. And it doesn't have to be a deposition. It can be just in your approach to life. So I'm a very holistic approach lawyer. And as you can probably tell, this helping people with CRPS is my passion. I'm a major sponsor of the RSDSA and what they believe in. I haven't done the longest day of golf personally, but my dogs have given, we'll talk about that in a minute, to the walk. I love speaking to people. Hopefully next year we're all together and I can see everybody face to face and y'all can see me. And people ask me, why do I do this? And I do this because I care. My dad's a minister, and I'm passionate about this. This is my calling. And so, if I can help you, great. If I've given you maybe some ideas or answers to questions you might have, then, I've done my job. So in closing, obviously, I want to thank you for your time. And you can see in this slide that my wife put together. She's the creative talent of our partnership. We have golden retrievers. Actually, the one on the left, solo, that's Franklin, and he unfortunately passed away earlier this year. He was 10. And on the right is Carmichael, and then our little puppy, Keenan. But our family is all in on helping people with CRPS, whether it's the dogs or me. I've got the CRPS colors, the RSDSA hat. My staff on color the day orange wears orange. So RSDSA is a community, and I thank Jim and Alexis and Jerry and everybody so much, and Hank, I know you're out there. Mary Pat, thank y'all so much for allowing me to be part of the community, and I hope I can make a difference.
Definitely. That was so awesome. See, Jim said, thank you. We do have a few questions in the chat, and I do want to remind everyone watching that we probably are not going to be able to answer any personal questions. I always want to just make sure I notice that. So I'm definitely going to look through and see what questions that we can ask.
Sure.
I know one question that's come up is, are there any states where you cannot practice? So
that's a great question. I love it. No, absolutely not. We are allowed to practice anywhere in the United States. What we do is we work with other lawyers in that state, put together a legal team, and then I get admitted. It's a legal term called pro hoc vice, but I get admitted to practice in any state in the country. And I frankly enjoy going to all over parts of the country and meeting people and trying to help them. It doesn't matter where it is.
Awesome. It's good to know. We have another question from Nurse Beth. Hi, Nurse Beth, who said, do you also guide CRPS patients or lawyers who are going through Social Security disability insurance process?
So my specialty is representing people on third-party cases.
Right.
There are other lawyers out there who represent people on Social Security disability claims or workers' comp claims. And sometimes they even sue health insurance plans for failing to provide the health benefits, that people need. I'm happy to guide people to them if I can, but that is something, that sometimes we coordinate with, but we are really focused on going after the people that cause people to have to go through the legal process with CRPS.
Right. I have a couple more questions, but Jim wanted to see if you have any as well.
I'd just like to piggyback on your answer just about going after health insurance companies. Have you seen anyone be successful that way, Bryan, if you were helping out?
It's really hard, Jim, because they're protected by ERISA. So you have to prove, kind of more bad faith, failure to look at a claim in good faith. It's very difficult. I mean, there are some lawyers out there who specialize in denial of health insurance benefits, but they're few and far between. Insurance companies, as you know, kind of had the upper hand. But one thing that we do, and my firm does, because we have a lot of expertise with this, is we deal directly with carriers. So in this case I had where the Ivig was ultimately approved, we had to get creative, and because they wouldn't approve Ivig for complex regional pain syndrome, but they would, because they don't approve it for small polyfiber neuropathy. But if you have something else, maybe it's for common variable immune disease, CVID, then Ivig is an appropriate product. And so, you kind of you get around it that way. So sometimes you can be creative with these health insurance companies, but it is it's a problem that we see.
It's a major problem when you're dealing with a disease that has no approved therapies.
Right. I mean, and that's why I said, this is exciting about ketamine being an orphan drug. I mean, maybe we're one step closer to ketamine getting approved by the FDA, and then health insurance companies won't have any choice. They'll have to cover it.
Right. Nurse Beth mentioned also low dose naltrexone has gotten that status too.
The orphan status?
Yes.
Yeah. And that's actually a lot cheaper than ketamine, by the way.
Yes. It is. It is.
Now, I know we have another session going on talking about advocacy, but this is a great question for you too. How can CRPS warriors and RSDSA as a whole support and educate other lawyers about CRPS?
Watch my video. No, I'm just kidding.
That is a good point. But
it's a kind of a hard question to answer. I mean, we feel like our firm has gotten involved with the RSDSA, and through that, we feel comfortable talking to people who have it and their support groups and all that kind of stuff. I mean, I'm a member of one of the CRPS forums. I don't really participate, but I get an amazing amount of information from that by monitoring it. How people feel on a daily basis. Some of my clients are part of it as well. I don't know because CRPS cases are really different because they're not unique, because it's a car wreck, it's a truck wreck, it's a slip and fall, it's a trip and fall, it's a workplace injury, it's a medical malpractice, it's a nurse malpractice. I mean, anything that somebody does wrong and causes trauma can result in CRPS.
Definitely. And I guess my question was for lawyers who are not personal, of course, injury, like, anything else that maybe you and your firm is not able to cover, I guess is what I was asking, but still makes sense. Okay. I know we had another question that came in, and I know you somewhat touched on this, but I thought it was still a good question. Is it negligence to not diagnose CRPS in time to avoid further damage? How does someone...
That is a great question.
Yeah.
And boy, I'm in dialogue with potential clients on that even as we speak. Because it is hard to prove that had the diagnosis been made, on 6 weeks post trauma versus 6 months post trauma, that the outcome would have been different. You know it, I know it, Jim knows it, even my dogs know that, but to prove it medically is very difficult. It needs to be a really strong case of it was obvious that they had CRPS and they just ignored it for a period of time, and as a result, they had severe chronic intractable CRPS that resulted in lots of need for spinal cord stimulator, and it's still not an easy case. I'll be honest, I've never taken a case like that because I just know the hurdle from a medical legal standpoint, the hurdle is so high.
Right.
Bryan, I wanted to thank you for really stressing about the life care planning, because that's something we deal with a lot when people are workers' comp and they're asked to settle. And generally they are trying to settle for peanuts.
Right.
Carrier. And I think it's so important.
Absolutely. And because you can do a work comp, you can do a life care plan within the context of work comp if you're talking about them trying to buy peace, if you're talking about them trying to settle the claim and get off the hook for all lifetime medical.
Yes.
Workers' comp, we get so many questions about comp, and it's just so frustrating because the goal of comp is to not necessarily be there as the support system for people, especially you know, the same defenses that I see in my lawsuits are similar in comp. Like, I mean, you had this little laceration on the job as a result of, you know, some scaffolding that it caused you to have this minor laceration. I mean, you're telling me now you can't work and you'll never be able to work again, and you need a $75,000 spinal cord stimulator. I mean, you know, we're not going to pay for that. We see that all the time, and you know, from my perspective, I can't help those people. I mean, I can send them to comp lawyers, but it's difficult for comp lawyers to get paid, which is why you know, there's very difficult system that the way it's set up. It's to favor insurance companies.
Yeah, I always say it neither works nor compensates.
Absolutely not. Yeah, that's an oxymoron, right? Workers' comp.
Yes.
See, there's another question that just came in about the life care planners. Is that something
Sure.
most attorneys consult?
Well, I mean, they should.
Yeah, I'm about to say.
Right. I mean, if you have a lawyer that's not thinking about a life care plan, then you probably don't need to use that lawyer because there's no other way to effectively demonstrate what your future medical is going to be. And, you know, quite honestly, the vast majority of our economic damages are future, not past. A lot of times people, they get CRPS, they get the lumbar sympathetics, those work, they're therapeutic and diagnostic. Then we're going on to the spinal cord stimulator. You get the psych eval, you pass that, you get the trial, you get 60, 70% relief. We're on to the permanent. And then, you know, by then the lawsuit, assuming you filed it, you know, timely, is ripe. And you've got past medical of maybe $100,000, but your future medical could be, you know, $1 million, $1.2 million, depending on how young you are and how many more procedures you're going to have. Yeah. So yeah, you have to have a life care planner. Now, I mean, I guess I'll caveat is what we can do is limited by, unfortunately, the nature of the beast, how much insurance is available for recovery. If it's a minimum auto policy in Texas, it's 30, but most states it's like 15 or 20. Unfortunately, unless you have your own first party, you know, big uninsured, underinsured policy, there's nothing. I mean, by the time you get your blocks, you're already past that much in medical. So there's no reason for that lawyer to go out and hire a life care planner because he's just spending money that should go to you. It's really the cases, you know, that I get involved in where there's a much higher potential for recovery. And so, you know, I'll spend $75,000 to $100,000 on a really good case. Usually they're less than that, but that's money I advance because I expect to get it reimbursed because I invest in cases I think we have a good chance to win. Otherwise, I wouldn't be, you know, working in my own office right now. I'd be working for the man downtown Dallas. But you know, if you have the right, and that's why I said, you know, it's kind of rare that I will get involved, but there's a lot of cases out there. If you have the right, you know, things come together, then we can put together a damn good case for you.
I know it is 8 o'clock. We do still have a couple of other questions that just popped. I saw someone's asking about if a case was closed years prior, is it able to be reopened?
You know, unless there's some really, really weird circumstance in the whatever particular state it is, the answer is no. I mean, once you settle your case, unless there's some open medical, which insurance carriers just never do because they want to buy peace. Right. You sign a release and you release them from any and all future liability for that incident. You can't come back in and say, you know, I didn't realize that this expensive medical treatment was going to be coming on 10 years later. I want to reopen it. You can't do that.
Right.
It's why it's really important to know in your state, know how long you have to file a lawsuit. You know, in Texas, it's 2 years. And in other states, you know, it's 3 years. It could be as short as 1 year, like Louisiana. You know, you hope your lawyer knows you have a period of time to file. Tennessee's 1 year. So if you don't get it on file, you're not going to be able to make a claim anyway. But you can't just file and then settle and then kind of reopen later. You just can't do that.
Right. So Stephen, it sounds like it depends on which state you live in if you're able to go through the process.
Yeah, California is 2 years.
Yeah, so I guess it would just depend. Oh, California. Okay, there you go. All right. So
Kentucky's 1 year. Yeah, every state's different. I mean,
right. Well, all right. So I actually did want to ask, because I know it is time for the expo hall. Are you going to jump? I know you just did your session, but are you also going to join or go back to the expo hall this evening?
I am
All
absolutely. But when does the auction end? Because I definitely want to go spend some money. When does that end?
Yes, good question. So the auction
Keep it open for him.
Yes, the auction ends tonight. As far as I know, the auction closes at 11:59 p.m. Eastern.
Oh, okay. So
unless Jerry tells me otherwise,
I can talk to people for as long as they want to talk tonight. Then I can go into the expo.
Awesome.
Into the auction.
Definitely.
Okay, good.
All right. Well, all righty, everyone. So this session is over, but our expo hall and our networking will still be open. So of course, with the networking, you can meet other CRPS warriors via video. We have extended the time. I know earlier in the week we were doing 5-minute sessions, and now they're 10 minutes. So of course, stay on as long as you can, as short as you want. Totally up to you. And then our expo hall is also open. You can go in there and learn more about RSDSA. You can, learn more about our auction that closes tonight. You can learn about our upcoming events. Color the World Orange is on Monday. CRPS Awareness Month kicks off on Monday. So many things going on. And then, of course, Bryan will be at his booth if you have additional questions that you would like to ask him. Now, just a reminder, we have recorded these sessions and they will go on our YouTube channel once they are edited. I do not have a timeline for that right now, but as soon as we can, we will get these videos over to our editor and we will get them up on our YouTube channel. And thankfully, YouTube also does have closed captioning. So we are happy for that. So once again, thank you all for joining us. We're so happy you all were able to join us here on this Thursday evening and throughout the whole week. It's been a great week. So,
and
Jen, you wanted to add?
I would be remiss, and I probably wouldn't have dinner at home for me if I didn't thank my lovely wife, Cheryl, for the creative content on the PowerPoint. Without her, this would have been a very dull presentation.
I'm glad you're going to eat.
Yes, me too.
Bryan, take care.
Thanks, guys.
Thank you so much.
Take care. Bye-bye.
Bye-bye.